All right, this lecture is on chapter 15, um, and it talks about the process of the trial. I want to uh, open this lecture by reading this quote on page 293. I think it is a nice statement about why we do the things we do, the way we do them. The criminal trial overshadows all other ceremonies as a dramatization of our views, representing the dignity of the state as the enforcer of the law, and at the same time the dignity of the individual when he is an avowed opponent of the state, a dissenter, a radical, or even a criminal. So you see the centrality and the importance of a the criminal trial to our system when it is ensconced in the Sixth Amendment. In the Sixth Amendment, it guarantees the right to a speedy and public trial. And just staying with the order of the presentation of the material in the book, we'll talk about what public means in just a moment. But the first thing that the book talks about is that you are entitled to a public trial presided over by a disinterested neutral, a judge who is not under the influence of any acquaintance or conflict of interest. And there's a discussion about the canons of judicial ethics and what would prompt a judge to have to recuse from a case. Of course, one would be acquaintance with the parties in interest. For instance, if there was a business relationship or family relationship or just a close friendship or uh, an intersection of relationships that could influence the judge, a friend of a friend, a a family member of a friend. If there's anything that can cause the judge to tip the scales in any way, the judge should recognize that and raise it. I've had judges do that in cases where they tell me something I don't know about a possible source of concern in a case, um, because the test is not whether you actually have a conflict of interest based on whatever connection to the parties or to the lawyers, but whether there might be an appearance of such a relationship such that the confidence in the criminal justice process is um, diminished from the standpoint of a dispassionate, or I'm sorry, a disinterested observer, the objective observer, the reasonable man test. Would someone looking on say, well, this judge has an interest in the case, um, and I wonder about the fairness of the process? So it's not about the factuality of it, it's about the appearance. Um, Sometimes it can have to do with a acquaintance or connection with the lawyers. Um, I, for instance, for a long time in my early part of my practice, I worked for the ex-wife of, no, hang on, let me straighten that out. I worked for the judge's ex-husband, and she would recuse from my cases routinely because although that judge and I were great friends, there was such acrimony between them. Um, somebody might look at that and say, well, if that person lost the case, it must be because she is mad at his boss. And then monetary cases, they had some ongoing financial connections, and it what might happen for me in a case that might be financially rewarding to a client, consequently me, it had that indirect uh, relationship to her former husband. Now, that wasn't a problem when they were married, which is interesting, when their finances were even more um, intertwined. But it's a situation where, case by case, you have to be cautious um, of those kinds of things. Political contributions. You know, I will routinely give a few $100s um, to a judicial candidate, but what if I give up to the limit every opportunity that you can make a contribution? You know, in the primary, in their runoff, in their general, I make a contribution up to the limit. Well, that may be that that judge has more of a um, I don't know, perhaps potential to be affected. But um, anyway, that is more an issue in civil cases um, than criminal cases because oftentimes criminal defense lawyers may give a couple $100. It's the civil side where people are so conscious of funding judicial campaigns. Read John Grisham's book, The Appeal, to kind of see how that money in politics affects the civil justice system. If you've read that book, it's fiction, but it reads more like real life than anything else. All right, so moving on, there is a discussion of the defendant being deprived of a fair trial based on prosecutor misconduct. That is, um, when there's no specific instance provided here, but if the generally it has to do with knowingly suppressing evidence, but um, that's often looked at in retrospect, where on appeal or a post conviction case, there is a situation where the defendant um, claims that some evidence was suppressed, it was material to their case, and then the courts look at that in context of harmless error, basically uh, whether um, the evidence against the defendant was so strong that the misconduct of the prosecutor didn't have any actual effect in the real world outcome. Um, so the next thing that's talked about is um, how the defendant is presented in criminal cases. They may not appear before the jury in jail clothing, um, and they have to be provided proper attire uh, for their trials. And so uh, that's generally my job as the defense lawyer to make sure that that is dealt with. If I have a client who's been incarcerated for a long period of time and is not coming to court from their home, I generally have to put their parents or family up to um, getting them some clothing appropriate to court. Oftentimes, I find myself having to fund that just because people are indigent, and I have to, spend the money or at least advance the money for that kind of stuff. I, I don't go shopping for them, but I often find myself footing the bill and have to give some fairly explicit instructions about how to dress. It's kind of an interesting thing. You don't want people to be overdressed and look like they are, in the minds of some people, overdressed to uh, seemingly sway people by their look. But what you want them looking like is neutral, and put the um, put the focus on the evidence, not the defendant looking overdone or not properly dressed. Um, so the the other concern often is in bringing someone to court from jail, the shackling. Um, you cannot let jurors see them in shackles, although it's generally apparent to someone that who's on a jury that that person is in jail or has been in jail. They'll be sitting there with a deputy behind them, especially in capital murder cases. Routinely, what I try, and I find that there are often two deputies seated in proximity to my defendant, generally behind us. So it's clear they've been in jail, but the visible shackling is unconstitutional. And so what we try to do is make sure that when jurors are present, that the person is brought in while the hallway is clear and unshackled, and when the jurors come in, they're sitting there uncuffed and all that. Another thing that I often deal with is where a person is this isn't visible; it's worn under their clothing, but a stun belt is sometimes put on a defendant before they're brought to court. And I have a routine motion I file that talks about how that is violates the presumption of innocence and is um, um, seemingly at odds with the dignity of that person who's put on trial. Um, I've never won the motion, but I'll keep making it because I think it is important to treat people in such a way that that their dignity as a person is intact. It often those sorts of intangibles are important to me. Um, all right, so the the issue of protecting the jury from improper information and protecting the neutrality of the jury is obviously a very, very important process in this um, trial. Um, and the jury selection process that we'll talk about later in this chapter is the main way that's done. But once you have a jury, how do you protect them from prejudicial information? The most drastic thing to do um, is to sequester the jury, that is, to have them held in situations where they're not in contact with people or in contact with information. Um, that's very drastic and is quite rare now. The O.J. Simpson case, I forget how long it lasted, but it was an extreme example of a jury being sequestered for a long time at tremendous expense. You're taking the um, those 12 jurors and however many alternates and essentially putting them in a hotel room. You are paying deputies overtime to um, to guard and keep an eye on them. So that's just rarely done anymore. There's no good reason why it's not, other than expense, I believe. Whether or not it's desirable in the first place is another question. From the standpoint of the defense, do you want a jury who is worn out, tired, and eager to get home? They're going to want to be in a hurry and probably conviction prone. But the reality is that the main reason that it's not done is it's incredibly expensive. Um, Jurors are admonished not to um, expose themselves to prejudicial information, to review media. They're now uh, so many times it has to do with wanting them not to go home and do research, since you can know something about anything from biochemistry to whatever with the stroke of a Google key. The problem is, number one, that is, um, the trial is supposed to be based on the evidence that comes in the right way via um, the process of cross-examination and testing the relevance and admissibility of it. But the other reason is misinformation. That's the problem with internet research, is either the information is wrong, or oftentimes it is presented uh, in such a way that a layperson can't sort it out. So anyway, it's very, very important that jurors be admonished not to do that. Now, do they take all that to heart? Absolutely not. I'm sure they go and read about the case on the media and research the issues and read about fingerprints and DNA and all that kind of stuff. But we have to try, and certainly, um, you're sometimes you find out about it after the fact when a juror is in deliberation and starts to talk about the research they've done. Of course, that typically requires one of the jurors to speak up and say, this person has committed misconduct. And that takes a lot of strength of character for that person to do so. Um, so, as far as publicity, there's a discussion here about the fact that the rarest thing that can be done, and almost there's no way to do it, is to restrict press coverage. Um, and what happens more frequently, very frequently, often at the uh, instance of other of prosecution or defense, is an order that keeps the participants in the trial from talking about the case. That is, an order would be directed towards the lawyers or the parties, and to the extent the court can enforce it, the families of the parties from talking about the case, and thus the media doesn't have people to quote, and so that's a way of reining in publicity. One of the things that the court can do um, is limit the means by which the press can participate, or the media can participate. At a minimum, someone has the right to come into the trial and view what's going on, listen, see it, hear it, and write about it. But what is not guaranteed is that a camera be there, or that they can record the proceedings. In fact, that is against the law in Alabama for anybody to photograph in a courtroom, to take any footage or record. And if you watch local news, you know that in Alabama, you're often seeing snatches of news footage taken from outside a door, taken from a window um, in a door to the courtroom. But you cannot bring cameras in a courtroom in Alabama or in federal court. Um, that's why you see sketch artists still working uh, in the courtrooms, as they depict the scene in a courtroom. It was very, very common to see that as a child watching the news in the early 70s, is um, the work of sketch artists, because almost nowhere did you have cameras in the courtroom um, uh, 40 years ago, 50 years ago. Um, just was unquestionably a bad idea, and maybe it was, but in time, in a lot of states, they have yielded to the presence of cameras in the courtroom. Oftentimes, that camera is in a fixed position. You can't obviously set up a sound stage. Um, the courtroom doesn't become your studio, um, and maybe there are just a number of one camera, two cameras, and they cannot depict the jury at any point. But anyhow, I don't look for that to change in Alabama very soon, and in fact, I hope it doesn't. The next issue is um, change of venue if there is prejudicial publicity, and that's a very rare remedy now. When I say very rare, I can only think of just a handful of trials in Alabama where venue was changed in the last decade, 20 years maybe. There, um, it's often asked for, but the law is not very helpful to a defendant seeking to have a change of venue. Um, it's very difficult to do um, because it's almost with a case with enough um, pretrial publicity, it is too accessible from wherever. Um, for instance, you have to used to it was an issue of getting outside the media market. For instance, the something that is covered in the Huntsville Times, the Huntsville television stations, for instance, might not be known to people in, say, Birmingham or South. Well, now we have things like AL.com. We have things like uh, social media and internet-based news that is less restricted to place, um, and so that's often a losing proposition. One pretty surefire way to get a trial moved to another venue is to actually attempt to find a jury that doesn't have extrajudicial knowledge, that is, knowledge of the case coming from other than the courtroom and the evidence, and people who have opinions based on that knowledge that is too there's not that they honestly say, I don't know that I can put that aside. Um, Especially in small towns, acquaintance with the parties is an issue. You'll find people that go to church with or know the uh, defendant, or they played ball with them, or their kids knew the children of the defendant, or victims. Same situation. And again, it's up to potential jurors to honestly say, I think it would affect my deliberations and my service. And if so, then you've maybe proven your point, and then you would get a change of venue. Almost always a defense concern, but um, there, as we I think talked about earlier in that movie Bernie, the state actually got the trial moved because the victim was so disliked, and the alleged perpetrator at the time was so very well liked in a town that the state claimed that it couldn't get a fair trial. All right, we're going to next talk about the arraignment process. So, an arraignment is often said to be the first formal proceeding in the court of general jurisdiction. In Alabama, that'd be the circuit court. When your case comes to the circuit court, either by an indictment or having been begun in district court and then an indictment obtained after presentation to grand jury. The first, when the case is docketed in the circuit court, in a lot of jurisdictions, the first thing you're going to do is have an arraignment. And it is the proceeding whereby the judge identifies you formally as the person in the complaint or the indictment, and asks if you understand the charges against you. This is going to be kind of like a repeat of the initial appearance in district court, if that's how the case began, via an arrest and initial appearance. But then the other thing that courts often do is make sure that the party has a lawyer at that point, and if not, discern whether they can afford indigent counsel. And all that will depend on whether or not that kind of thing had happened earlier in the process, like in district court, where um, the indigent defendants are identified and provided counsel earlier. But certainly by that time, because you're moving closer to trial, and then the court calls upon the defendant to enter a plea, um, either generally one does not plead guilty at the arraignment. It generally is a plea of not guilty, or occasionally not guilty by reason of mental disease or defect. And that is mainly what happens at an arraignment. Sometimes trial dates are discussed, motion, scheduling, that kind of stuff. The book mentions that some jurisdictions do the arraignment right before trial, and that is the way Huntsville does it. Generally, the week before, but that typically is done earlier in the process to identify issues and problems and all of that in cases earlier than right up on the point that they're ready to go to trial. There's some discussion about a trial in absentia. Certainly, that isn't done sometimes where a defendant is tried without being present, and it's very unusual when that happens, but a person can't defeat the operation of the justice system simply by not being there. And there's some factors like whether the trial can be quickly rescheduled, burdens on witnesses, and so on. But typically, absence the first time is there's assumed that something's going on and that it's not intentional. But if a client, if a defendant does intentionally avoid coming to court, then there can in fact be a trial without them in the absence of a good explanation for why they're not present. All right. So we talked about entry of a plea. Notice we didn't talk about a plea of nolo contendere or no contest. That generally is not available in Alabama. When I say generally, it just isn't. But there is the availability of the Alford pleas, and Alford pleas are discussed in this case, North Carolina versus Alford, on page 297. And it involves a situation where a person maintains their innocence. However, they stipulate that the state could make a prima facie case against them, and they enter a plea of guilty, because generally there's a great reluctance to allow a person to enter a guilty plea while maintaining their innocence. Guilty pleas, at least theoretically, conceptually, are for the guilty, not the innocent. But this was done, I think, as a compromise to allow people to save face a little bit and not cost the system a trial. In municipal courts or misdemeanor courts, where the stakes are much lower, you'll find it very uncommon that you can do such a thing as talk innocent and plead guilty at the same time. Generally, a court in those kinds of settings are either reluctant to let defendants do that just out of, we're not going to let the innocent plead guilty. If you're innocent, let's have a trial. There's a cut through the bullshit. And if you're guilty, say so. If you're not, let's have a trial. But if it's a person who's trying to avoid a 20-year sentence or a life sentence, and they feel like they have a weak defense, and they're offered a plea to, say a 10-year sentence with 3 years to serve or something like that, they'll often cut their losses. And I hate that when a client tells them they're innocent and yet they want to take a plea. But that is accommodated in this case of North Carolina versus Alford. I'll read this section to you. Thus, while most pleas of guilt consist of both a waiver of trial and an express admission of guilt, the latter element is not a constitutional requisite to the imposition of a criminal penalty. An individual accused of crime may voluntarily, knowingly, and understandably consent to the imposition of a prison sentence, even if he is unwilling or unable to admit his participation in the acts constituting the crime. So that case, as decided in 1970, talks about why that is permissible. But there's a lot of scrutiny given to those pleas, and some district attorneys, some judges won't allow them, and for good reason. And I have a bad feeling, for it. It seems like a way that that the system is in danger of making a mistake when this kind of thing is permitted. All right, let's take the situation where you have a negotiated plea agreement and how that actually works. We'll break this up, and that'll be the first topic in part 2.